I'm Cynthia Rowland, and this is episode 111 of EO Radio Show, which is a refresh of our episode 53, Real Estate Leasing Tips for Nonprofits, first dropped on September 11th of 2023. In this episode, I talk with my partner Quinn Arntsen about leasing issues for nonprofit tenants. Leasing real property is a big commitment, and for nonprofit executives that haven't been through the process a few times, it can be daunting, especially for long-term lease commitments. Quinn walked us through the basic issues and the components of a term sheet for the major items that need to be considered by the nonprofit when beginning lease negotiations. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. Today, I'm happy to have Quinn Arntsen here to talk with me about leasing issues for nonprofit tenants. Quinn is a partner at Farella, Braun & Martel, based part-time in San Francisco and part-time in the Napa Valley. He divides his practice between traditional real estate work and advising clients in the wine industry on transactional real estate matters. Quinn has represented clients in a wide range of projects, acquisitions and dispositions for real estate developers and investors, representing borrowers and lenders on real estate secured financing and loan workouts, landlord and tenant side leasing of office, life science, research and development, industrial and agricultural real estate, negotiating and structuring joint ventures and other real estate investment entities, and assisting private clients on a wide range of real property issues. As you'll no doubt notice in my conversation with Quinn today, Quinn combines a calm, low-key demeanor with exceptional analytical abilities and, most importantly, an outcome-focused approach. His goal always is to get things done. With all his clients, Quinn knows their industry, understands their needs and overarching goals, and can help them focus on what is really important, helping them to do their business. Many of my nonprofit clients have had the pleasure of working through real estate transactions with Quinn, including standard office lease projects and tricky property management agreements. He's an absolute pleasure to work with. Welcome to the show, Quinn. Thanks for making time for this conversation today.
Thanks, Cynthia.
Let's start out. Today we're going to focus, there's so many things you and I could talk about, but today we're going to focus on leasing issues from the nonprofit tenant point of view. Really, let's start at the very beginning, which is usually a term sheet or a letter of intent. Walk us through how to start thinking about getting a lease together as a tenant and thinking about the basic terms or LOI, whatever it's usually called.
Yeah, definitely. So from the tenant standpoint, the LOI or term sheet is a very important part of the lease process. Typically what happens is tenants will engage a broker. They'll go out, they'll look at a few properties, find their favorites. Maybe they'll have one or two that they're considering leasing. Either the tenant or the broker will reach out to the landlord, say, hey, landlord, we like this property. What are the terms on which you'll lease it to us? From there, the landlord will generally put together a term sheet or letter of intent. Sometimes we call them LOIs, and that will summarize the key terms of what the leasing relationship will be. Often tenants will just sort of gloss over this. They'll think, oh, I found a space. Here's a page or two document that summarizes the basic terms. I'm fine with it. Let's go straight into lease negotiation. Tenants can really benefit from focusing on the LOI, focusing on the term sheet, and negotiating things at that stage.
So do they have much leverage? I think a lot of tenants, especially nonprofit tenants that don't do this routinely, might consider it kind of a take it or leave it set of terms that they're initially offered. And I guess maybe that kind of depends on where you are in the real estate cycle. But what are you seeing about leverage these days and in general?
Yeah, so it does depend some on the cycle. Like right now, it's a down market. Tenants have a lot of leverage. 3-4 years ago, when things were hot, tenants didn't have as much leverage. But I mean, in general, even when it's a down market or even when it's a hot market, the LOI or term sheet stage is a great opportunity for tenants to negotiate. Because at that point, the landlord hasn't locked in the tenant. The tenant could still go look somewhere else. The tenant hasn't put as much money into planning for this space. they haven't gotten their heart set on this perfect space, the tenant can walk. And the tenant can really use that position to try to extract more benefit from the landlord. And that can either be in terms of rent, like actual dollar figures, like trying for lower rent, trying for lower cost reimbursement, trying for more tenant improvement allowance, or it can be in other terms, which parties don't often think about as much, but can be very worth negotiating at this stage.
So what are some examples of that?
So some things that can fall into that category are transfer rights, extension terms, early termination rights, what happens if the tenant is slow in delivering the premises, how rent is adjusted, kind of all sorts of things. Landlords and kind of landlord leasing agents, which are often the people on the landlord team that are responsible for this initial negotiation. They're often very focused just on the dollar figures. So if as a tenant you come in and you try to say like, all right, we'll accept those dollar figures, but you've got to give us 2 extension terms for 5 years each at market rent or 95% market rent, something like that. That can be a great opportunity to try to get concessions on those points. Something else to keep in mind with that is sometimes landlords in their form LOIs, these documents can be a page or two. I've seen some that are 10 to 15 pages. I mean, those are clearly much bigger leases, more involved projects. But the point is the level of detail can vary widely. And often, the more detail that's in them, at least the first draft, the more the landlord will benefit. The landlord will try to sneak those terms in while the tenant's not necessarily focused on them. And then, although the term sheet isn't binding, the landlord can then say, oh, no, you signed this document. It said A, B, and C. You've got to stick to A, B, and C. Otherwise, you're renegotiating this and we're going to reopen everything. So it is good if there's boilerplate, if there are a lot more terms in there, to actually read them and focus on them.
So let's talk a little bit about the actual premises, what you're leasing. Sometimes I see a little bit of confusion there and also maybe not focus on the details of what the premises are. What are some common issues that come up as the, let's say, less experienced nonprofit is thinking about their first space that they're leasing and how they should think about looking at the premises description?
First and foremost, you want to make sure that what's described as the premises matches your understanding. Sometimes that's you're getting a whole floor. Sometimes that's you're getting a suite. Sometimes it could be you're getting a whole building. You want to make sure that that's right. Just kind of the basic description of the premises matches. Sometimes there can be things that are excluded. So say you're leasing all of a floor except the conference center. Again, you want to make sure that's spelled out. Along with that, a lot of buildings, especially recently, new projects get built. They have lots of tenant amenities. That could be a gym. That could be a shared cafeteria. That could be conference centers. That could be outdoor space. It's good to specify what rights the tenant has to use that space, how often they can use them, is there additional cost for it, just in general, what restrictions are on that space and what rights tenant has. And this also comes into play with parking. So parking is another thing. It's often not quote unquote part of the premises, but it is still something that's leased. And if you're getting 10 parking spots and you don't want to pay for those parking spots, that needs to be called out in the term sheet. One other factor to keep in mind with the premises is the square footage. Rental rates are often determined by square footage. The broker will say, hey, we've got you this great rate of $3 a square foot. And it's like, all right, that's all fine and good. But you also need to figure out what the actual size of the space is. And there are different ways to measure. Landlords can sometimes, I'm not going to say pump up the square footage, but the measurement systems often benefit the landlord. So if you can, it's nice to be able to spell that out in the lease and even maybe have a right to remeasure the square footage once you're actually in there, because that's ultimately going to be what determines your rent if you're paying by square footage.
Mm-hmm. Another common thing that we see in the LOI or the term sheet is the term, the number of years. And maybe we also get into later on early termination rights and extensions and delays, all these things, lots of issues about the term of the lease. Talk a little bit about commencement date and rent commencement date and how they differ or could differ. Maybe they're the same.
So let me even go back a little bit and talk about term generally. For the length of the lease or how long a tenant wants to lease a space can vary a lot depending on the tenant and kind of their proposed plans, whether they're going to grow, whether they're going to stay the same. whether their purpose might drastically change. So in thinking about term, it's really important to give some thought on the medium-term plans and even long-term plans of your organization. So you might be a new nonprofit, you might be starting out, and you think, all right now, all I need is 3,000 square feet. But if you're hoping to grow, that might not be enough space. So think about what that means for your term. Because if you get locked into a small lease for, say, 10 years, yeah, you might get a better rental rate, but you might outgrow the space in 3 or 4 years. So that's less useful. So give some thought as to your organizational plans when deciding on the term. But to your question on commencement date versus rent commencement date. So this often comes into play when space is not ready or space needs to be built out, which most office space, there's going to be some improvement work done to it before the tenant moves in. And so there are different ways to think about commencement date, which is often when the tenant has the right to start occupying the space or start doing work in the space, versus rent commencement date when the rent actually starts. And so as a tenant, you want your rent commencement date to be as late as possible. Like you would love to get maybe some free rent beforehand. So maybe you get into the space August 1st, but your rent doesn't start until January 1st. That's great. It's good to spell out that distinction. And then same with if you need to build out the space, or if you are doing work, you would rather have access to the space to do your work rent-free prior to the rent actually commencing.
That might be a bit surprising to some tenants. And I guess in a down market like we're in now, you might have more success in getting a little free rent period while it's getting built out. Because you might be in another space and having to pay rent at 2 places while you're getting the new one ready. That can be pretty burdensome. Yeah, that's a good thing to keep in mind. You don't necessarily have to start paying rent when you start having access to the building. But there's other things that you might need to have in place once you start working in the building, even if your rent hasn't started. Maintenance, all those things would start as soon as the lease commences, but maybe the rent is late.
That's definitely true. Yeah. So again, be cognizant of that. So if you get the space, in this example, August 1st, or to start doing your improvement work or start setting up, and maybe you can operate a little bit too, but your rent doesn't start till January 1st, there's a good chance that even starting August 1st, you'll have to maintain insurance. You'll have to reimburse landlord's taxes or property taxes. You'll have to reimburse insurance, landlord's insurance costs. So all those costs often begin right at the commencement date, not at the actual rent commencement date. So again, it's good in the term sheet to specify what amounts tenant has to start paying when and what other obligations the tenant is responsible for. You can sometimes end up in a weird situation where, say, the commencement date is August 1st, tenant and landlord are both building out space in there, but landlord's still responsible for securing the premises or something like that. Well, that's weird because you don't have exclusive possession. You aren't in there. Landlord's still going in there. So you want to make sure you aren't potentially on the hook for broader liabilities than you might otherwise expect.
It's probably a whole other episode to talk about insurance issues with leased space, but you'll want to have a conversation with your insurance broker before you start working in the space to make sure you've got the right coverages and the coverages the landlord expects to see.
Absolutely. And I mean, on that note, you're totally right. Tenant insurance is a whole separate episode. But usually a landlord will require that the tenant obtain insurance and provide evidence of insurance to the landlord prior to moving in. So this again gets to the commencement date and thinking about things. You might have a lease that says you can get in there August 1st, but if you have to have your insurance in place before you can get in, and there are delays with your insurance broker or delays getting insurance, you might not be able to get in there for a couple weeks or a month or two, in which case you've lost the benefit of that earlier period, which you had negotiated.
Yeah, the clock is ticking. Yep. So speaking of the clock ticking and delays, so that's one delay, tenant delay, because you can't get the insurance in place. What are some other things that you see that have been traps for the unwary tenant? Aside from the disaster sorts of scenarios, but
yeah. So tenant delays or landlord delays are also something that's often negotiated in the term sheet. And this is really tied to when the premises are delivered to the tenant for the tenant to be able to occupy. So if the landlord's got to build out the space, then as the tenant, you don't want rent to start until the landlord's delivered the space and you've gotten in there. But at the same time, you also need to be able to hold the landlord's feet to the fire a little bit. You don't want the landlord taking an extra year and then you can't get into your new space, your old lease expired, you've been paying holdover rent, you're liable to your old landlord for damages just because your new landlord was slow in getting the work done and delivering the space. So it's a good idea always, but it's especially a good idea if you have specific deadlines to get into the space, that there are consequences for the landlord if they're delayed. So often that's rent abatement. So say they've got a target delivery date. If they miss that date by more than 30 days, landlord gets extra free rent. If they miss it by more than 60 or 90 days, free rent doubles. And sometimes even if they miss it by a certain period, the tenant can just terminate. Now, the termination can kind of be a double-edged sword because as a tenant, you aren't going to find out about this until right before you had been expecting to move in or even after you expected to move in. So there's a good chance you're out of your old space, you don't have another space lined up, and you need space. So in practice, as a tenant, you're probably not going to terminate, but it can still be a tool there to try to force the landlord to move faster and get the work done.
Yeah, so this is one of those things that you'd really want to watch out for in your term sheet and not just gloss over it and let it fall into the boilerplate when you're further down the road in the process. And I guess the flag for me would be when the landlord has significant work they need to do. And I mean, it may not even be all that significant. It's just a gating item. If the elevator doesn't work, you can't get to the space. So if the landlord needs to fix that before you move into the building, that's going to be a pretty essential term sheet item, I would think.
Definitely. Another thing that can cause this kind of delivery delay is if there's an existing tenant in the space.
Oh, right.
And if the tenant isn't getting out, or if the tenant is dragging their feet, or there are other reasons that you or the landlord think the current tenant might make it painful to get out. Mm-hmm. If the previous tenant's in there, you can't get into the space. So that's another way tenant delay or landlord delay can come into play. It is good to spell out the consequences for a landlord delay in the term sheet because that is a business term. And I've definitely seen landlords say, oh, this wasn't addressed in the term sheet. If you had wanted it, you should have said something in the term sheet. I'm not changing the business deal now. I'd have to go back and my board would have to approve and we'd have to rethink everything. No way are we going to do this. So business terms like this with dollar figures attached, it's good to have in the term sheet.
Yeah, that's a good word to the wise. And I think that's a good segue. And you touched on this a little bit, and that's early termination rights as a feature of the term sheet. When does a tenant have leverage there? And I guess early termination works both ways. Landlord or tenant could terminate early, and probably nobody really wants to.
So early termination rights are generally there for the tenant's benefit. Because again, as I was saying earlier, for a tenant, when thinking about the term, you should think about your long-term plans. But often you don't know what those long-term plans will be. You don't know if your headcount might double in 5 years. And if your headcount does double in 5 years, you're going to need new space. So if you think something like that is a possibility, it can be worth negotiating for an early termination right. Typically, the way early termination rights appear in leases is there will be a certain window, say 5 years in, 7 years in, 3 years in, where the tenant can terminate. Often there's a termination fee, but during that time, if the tenant wants out, they can give a notice and terminate. Then the lease terminates a couple months after that, maybe a year after. It all just depends on what the provision says. But that is something where if you want it in the lease, you need to get it in the term sheet. Because landlords, that's a substantive business term that a landlord's not just going to give you after the term sheet is signed.
Similarly on extension options, or maybe that's not quite as sensitive for landlords?
That can still be pretty sensitive. If it's important for the tenant, it's good to get it in up front. Often landlords will agree to add extension options during negotiation, but your rent's going to have to reset to a market rent. The landlord's rationale is, hey, if this tenant is going to pay market rent, I'm fine if they extend because it's not like I'm going to get a better deal somewhere else. But if you want to lock in your extension term at your current rent or kind of your current rent increases, or sometimes tenants will get extension term, their rent is say 90% or 95% of market rent. That you really want to include in the term sheet, because otherwise the landlord's not going to want to give you an extension right where there's a good chance it could be below market rent. And so with putting the extension rights in the term sheet, it's good to, one, specify how many you have, two, how long each one is. So say you have 2 5-year extension rights or 3 3-year extension rights or something like that. And then how rent is determined. So whether it's a fixed amount, fixed increases, whether it's a market rent. If it's a market rent, you can get into a lot of nitty gritty on how you determine market. We don't need to specify that in the term sheet. And then how rent increases during the extension term. So those are all good things to include in the term sheet.
So that's a great segue to the next major point, I think, in term sheets, and that's the base rent itself. Before we talk about rent in general, I just want to drop a note here for nonprofit tenants that are related to their landlord. If the landlord is a for-profit, either business or the founder, or has some sort of a relationship to the nonprofit, go back and listen to our episodes on insider transactions. And the rules are slightly different depending on whether the nonprofit is a public charity or a private foundation. Its tax category is going to drive the specific rules for negotiating, if it's at all possible, with a related party landlord. But with that being said, so for our conversation here, we'll assume that the landlord and the tenant are not related and that there's not an insider transaction issue for our nonprofit. So with that little tiny bit of background, Quinn, you want to talk a little bit about how rent needs to be described in the term sheet and the various components of it?
Yeah, so rent is something that is always going to be in your term sheet. It's probably going to be your first line of your term sheet is going to say the space. Your second line is either going to say your term or your rent. It's critical, something everyone cares about. Other than just the base rent, like your base dollars per month or dollars per square foot, or however you determine that, the other key things to think about with rent are rent adjustments. So how it changes year over year. Almost always that's a fixed percentage. And the market, or what is the market term for fixed percentage, it varies. A couple years ago, 2.5%, 3%. Prior to the current downturn, it was getting up to 3.5%, sometimes more than that. So rent adjustments, it's a good thing to check with your broker on and get input on what is currently market. The other thing there is the timing of rent adjustments. So typically rent increases every year, but something you might be able to do as a tenant is say, all right, well, our lease is starting in August, but we want our rent increase date to be January 1 of each year. And we don't want it to be this January 1. We want it to be the January 1 after. So that by delaying the rent increase date, you can end up having fairly significant savings over the term of the lease. The other factor to think about with rent and base rent is abatement or free rent periods. So often leases will have a free rent period where the landlord is saying, tenant, you can occupy for the first 3 months, first 6 months, you don't have to pay any rent. And the reason landlords do that, other than just trying to entice tenants and get them in, is that by giving a free rent period, they can often charge more rent after the fact. And by charging more rent after the fact, the property looks better if they go to sell it or if they go to put financing on the property. So I guess for tenants, think about it as yes, you're getting this nice thing with a free rent, but also keep in mind that it often comes in exchange for a higher base rent. So just try to think of the whole picture during negotiations. The other aspect of rent is additional rent. So tenants will pay their base rent. That's determined either on a square footage basis or for this premise you're leasing, you pay X dollars per month of base rent. Additional rent are just costs you pay above that. So the three structures of handling additional rent are you can have full gross rent, which is really the landlord pays everything. So your base rent is kind of an all-in number. You pay that. Landlord then takes care of property taxes, their insurance, operating expenses. The next option is modified gross or base year. And so under that structure, the tenant or the landlord pays the operating expenses, insurance, taxes for the base year, which is often either the first calendar year of the lease or the first full calendar year during the lease. And then the tenant pays increases. So say the total taxes, insurance, operating expenses were $2 a square foot in the first year, and then in the second year, they were $2.15 a square foot. The tenant is responsible for paying that 15-cent per square foot increase. That's a pretty common structure. It gives the tenant some protection while also protecting the landlord from significant cost increases. And that's probably the most common structure for kind of a multi-tenant office building. The final way you can do it is called triple net. The idea of triple net is really the tenant pays everything. So the landlord is receiving their base rent. It's kind of like that's what the landlord gets as their profit because the tenant's responsible for all the other costs. Triple net is not very common for office leases or multi-tenant buildings, but it's the norm for whole building leases. So if a tenant's leasing an entire building or most of the space, it's usually going to be set up as triple net.
And we use triple net when we do have the related party transactions, if it's otherwise allowable. And the benefit to using the triple net is then you might say pay the related party $1 or some nominal amount for the space, but then pay all the on a triple net basis, pay all the property taxes, all the insurance, and all of the maintenance, insurance, and property taxes. Yeah, that's the three. I do see that a fair amount in my related party leases with nonprofits because it just minimizes the amount that could be treated, looked at by the IRS or a regulator as a benefit to the landlord. But anyway, I digress a little bit. That does lead us to operating costs. What sort of costs does a landlord expect the tenant to cover? I mean, I guess things like cleaning sometimes are cleaning, other additional costs, things like that.
Cleaning, utilities, ordinary repair costs. Often landlord's insurance goes into this category. Often the property taxes or share property taxes can go into this category. And this is something where the provision in the lease itself that deals with this could be, believe it or not, a couple pages talking about what is operating expenses, what are operating costs that get passed through, and what don't. So you don't always need to focus on this a ton in the lease itself unless the landlord focuses on it. If the landlord focuses on it, you need to review that carefully because otherwise the landlord might try to pass through a bunch of costs to you that shouldn't be yours. And examples of those could be like if the landlord decides to buy fancy new artwork for the lobby or redo the exterior or do a major lobby renovation or put on solar panels or something else that benefit the landlord a bunch. As a tenant, you don't want to be paying all the cost of that. There are a lot of ways you can negotiate that, the specifics around that in the lease itself, but just good to have an eye out for it.
Yeah, and I would say that to me, that might be a red flag in the term sheet. I guess if I'm a tenant, I want the term sheet to say I'm not paying any operating costs above and beyond a narrow category. And then the landlord knows what their plans are. And so that'll at least put the issue front and center at an earlier stage in the negotiation, I would think.
Definitely. Yeah, it's a good way to flush out how collaborative and cooperative your landlord's going to be.
Yeah. So let's, nonprofits, we always like to talk about taxes. Let's talk a little bit about how to deal with the property taxes. For most nonprofits in California, and again, we've obviously been very California focused here, but a lot of what Quinn has been talking about is universal, applies in any state. But in California, the property taxes on the building can go up dramatically during the term if the landlord sells the building. That's one thing to flag here. And then secondly, for a nonprofit that is a 501c3 nonprofit, often in California, if the property is owned by a nonprofit and leased to a nonprofit, then it may be entitled to property tax exemption. But otherwise, if your landlord is not a nonprofit, there's going to be property tax on your space. So that was a long-winded introduction for Quinn to make some comments about how nonprofits can approach property taxes in the term sheet.
Yeah. So the comment on when a nonprofit tenant might be able to be exempt from property taxes is very helpful to know and keep in mind, because if you're exempt, you don't want to be paying them, and you want to make sure whatever is done to obtain that exemption is done. On the property tax increases, this comes into play if you've got a base year modified gross rent structure or a triple net lease. And that's where tenant is responsible for either all of property taxes or increases in property taxes. As Cynthia mentioned, in California, property taxes generally don't increase very much. It's just a small fixed percentage every year, unless there's a sale of the property or there's major construction work or something like that, in which case they can go up dramatically. And so tenants will often try to negotiate what's called Prop 13 protection. Prop 13 is the California law that implemented this limitation in property tax increases. But so tenants will often try to get Prop 13 protection in the lease. But if you want Prop 13 protection, it has to be in your term sheet. A landlord is never going to agree to Prop 13 protection unless it's in the term sheet. So think about it and think about whether the landlord's likely to sell during the term and how much of a tax increase would get passed through to you, things like that, when deciding whether to fight for Prop 13 protection. It definitely can be a significant savings if the current owner has owned the building for a while and they're thinking of selling, because you can have, the property taxes can increase drastically.
Yeah, and I guess that's a good way to find out if that's what the landlord's intentions are if you put it in the term sheet. Because if it's not in the term sheet and then you gloss over the boilerplate that talks about property tax increases, by the time the nonprofit tenant realizes it's a problem, there's nothing you can do about it. A very important term sheet point. A couple of other things for term sheets, tenant improvements and security deposits. So TIs, I guess we could talk a lot about tenant improvements, but what does that often look like? And who's responsible for the construction and all that detail? It's a joint thing, right? It's their building, so you can't just do whatever improvements with whatever contractor you want. And neither should they be able to, especially if it's a long-term lease.
Right, exactly. And this varies a lot depending on the space that's being leased, kind of how big it is, and what work needs to be done to it. So if a tenant's leasing one suite on one floor of an office building, the landlord's just going to say, I'm going to build it out this way. You can give me some input on plans, but really, this is how it's going to be, and you'll deal with it. Whereas if if a tenant's leasing multiple floors of a building, then the tenant has a lot of leverage to say, I want it built out this way. I want you to redo the carpets, put in these walls, give me new conference rooms, give me a kitchen, things like that. That often needs to get spelled out in the term sheet. This can come in a couple ways. One, you'll specify who is doing what work. So whether landlord's doing all of it, whether landlord's just delivering an empty shell and then tenant does work, or rarely is tenant going to do all of it unless it's like a whole building, something or other. And then you want to specify how much the landlord's paying for it. So usually the landlord will agree to pay X dollars per square foot. And then you calculate that. That's how much the landlord puts towards improvement costs. And that goes towards both landlord's improvement costs or possibly reimbursing the tenant if the tenant is directly incurring improvement costs. So all of that really needs to be fleshed out in the term sheet. You don't necessarily need to know the plans. You don't need to know exactly what you're going to build or what the landlord's going to build, but you need to know who's going to build what, how much the landlord's paying for it, and what the process is for agreeing on those plans.
So what do we do about delays? I guess this kind of ties back to our earlier conversation about whose fault it is, but you want that addressed in the term sheet.
Exactly, yeah. And most of the delay provisions are related to tenant improvements and kind of what happens if the landlord's doing the work and they're slow, or that's generally how the landlord delay comes up.
Final topic for term sheets, and I think a really critical part of the term sheet LOI is the security deposit. How landlords think about the security deposit as well as how the tenants do. Can you talk a little bit about the different ways the security deposit can be provided? Sometimes it's cash, sometimes it's not. What are some options there?
Yeah, so most common is cash. That's simple. That's everyone has leased an apartment at some point. They give a check to the landlord when they started out. People are just used to a cash security deposit. That can work if the amount of the security deposit is fairly small, like a month or two of rent. If, however, if the landlord wants a much larger security deposit, which can happen, say, if the tenant doesn't have as much credit, like if you're a new nonprofit or fairly new and you're just starting out, the landlord might say, hey, I'm not going to spend $300,000 building out this space for you when I'm afraid that you might go under within a year and I'm never going to recoup that. So if the landlord is doing a lot of work, and if the tenant doesn't have much credit or is a potential insolvency risk, then the landlord's going to want quite a bit more. Like sometimes landlords want 6 months, sometimes they want 12 months, sometimes they can want more than that. And if they want more than that, the best way to do it usually is with a letter of credit. So that requires the tenant to go to their bank, say, bank, I will pay you some amount of money. You'll give this letter of credit to the landlord. The landlord then holds the letter of credit, and the landlord is allowed to draw on the letter of credit to the same extent they could draw on the security deposit. So, for example, if the tenant doesn't pay rent, or if the tenant breaks something and doesn't repair it, the tenant can draw on the letter of credit. And the value of the letter of credit for the tenant is you aren't out all that cash for a really long time. Like you aren't out 6 months rent or 12 months rent for the entire term of the lease. You have to pay a fee to your bank. There is some fee involved with it, but it's still, you have that cash. Like it's still in your account, or you've done something else to get the bank comfortable that you'll be able to pay if there is a call on the letter of credit. The other alternative to a cash security deposit or letter of credit is getting a guarantor. So often nonprofits will have deep-pocketed beneficiaries behind them. Those people are often willing to sign a guarantee. And if they're willing to sign a guarantee, then the landlord is much less concerned about security deposit, much less concerned about the consequences of a default or something like that, because the landlord will know that there's someone there who could support a claim if the landlord ends up being harmed. So that's another great option for nonprofits.
Yeah, we see that a lot. That can be a really powerful way for a founder or a grantor, or somebody who's really supportive of the nonprofit's mission at relatively low cost to them, because they know that the nonprofit will succeed. Because, typically if a problem comes into play, the guarantor or the founder is just going to make the grant to the nonprofit anyway and get a charitable tax deduction, and, everybody's happy in the end. But nobody expects it's going to go that way anyway. So those are some really good practical options to the security deposit conundrum that new nonprofits can face. So with that, Quinn, I think we've covered a lot of term sheet ground. Hopefully we can do another episode in the near future on kind of the nuts and bolts and the nitty gritty when we start turning this term sheet into an actual lease agreement. And we'll talk about boilerplate. So, that'll be a gripping.
Thrilling topic.
Yeah. So with that lead up, I'm sure everybody will be waiting impatiently and breathlessly for our next episode. But thanks for joining me today, Quinn. This has been really informative, and I think it's going to be useful to a lot of listeners. So thanks for joining me, and let's set a date for our next one.
Absolutely. Thanks for having me. It's been a pleasure chatting.
So listeners may want to check out the show notes for links to additional resources. There is a webinar on the Farella website that includes an in-depth breakdown of what nonprofits need to know about landlord-tenant relationships and insurance. So that's another good resource. And we'll put some other articles and links in the show notes for those who want to learn more. So that's all for this episode. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you'd like us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.